forbidden by law. Directors should not be permitted to use stockholders' money for such purposes, and, moreover, a prohibition of this kind would be, as far as it went, an effective method of stopping the evils aimed at in corporate practices acts. In 1907, Congress passed the Tillman Act, which banned all corporate contributions to candidates. The Senate report on the legislation said, and I quote, "The evils of the use of corporate money in connection with political elections are so generally recognized that the committee deems it unnecessary to make any argument in favor of the general purpose of this measure. It is in the interest of good government and calculated to promote purity in the selection of public officials." Austin falls right in line with these legislative and judicial interpretations. These interpretations assert a clear governmental interest in the differential treatment of corporations and individuals. The purpose of Austin is to prevent both corruption and the appearance of corruption in our elected representatives. Now, the majority of this court refers to our ruling in Buckley versus Vallejo, 1976. They lean heavily on this statement: "The concept that government may restrict the speech of some elements of our society in order to enhance the relative voice of others is wholly foreign to the First Amendment." But this elegant phrase cannot support the weight our colleagues have placed on it. For one thing, the Constitution does permit many restrictions on the speech of some in order to prevent a few from drowning out the many. For example, we permit restrictions on ballot access. We permit restrictions on legislators' floor time. Indeed, in Austin, we expressly ruled that the compelling interest supporting Michigan's statute was the state's need to confront the corrupting potential of electoral advocacy financed by corporate treasuries. The majority leaned still more on another case, Bellotti, 1978, which was about a referendum. Massachusetts had a law that kept corporate money out of a referendum election. The court overturned that law. Today's majority says that ruling means just one thing. The Bellotti case forbade distinctions between corporate and individual expenditures. But I can tell you that Austin sits perfectly well with Bellotti. In Bellotti, the Massachusetts legislature tried to prevent corporations from influencing a referendum. We ruled against the state, but not as a First Amendment protection for corporations. We ruled as we did largely because we saw no compelling state interest in keeping corporate money out of referenda, because referenda deal only with general public concerns. But candidate elections are different. States do have a compelling interest in candidate elections. Why? Because in a democracy, the public believe that its representatives owe their positions to the people and not to the corporations with the deepest pockets. I see no essential disharmony between Austin and Bellotti. Austin was about political candidates. Bellotti was about referenda. This court's majority view of political corruption is short-sighted. Their construction rises on the claim that the government interest in preventing corruption, real or apparent, is limited to one kind, quid pro quo, the exchange of money for governmental favor. This view disregards both our constitutional history and the demands of any democratic society. Federal Judge Collar-Cotelli has made several official findings about political corruption. She found that corporations and labor unions routinely notify members of Congress when they broadcast electioneering communications about the members' elections. She did. She found through her studies that corporations and labor unions routinely notify members of Congress when they broadcast electioneering communications about the members' elections. In turn, members of Congress like such broadcasts. They are especially grateful for negative issue ads that free them to go positive, and thereby seem to rise in virtue above the fray. She also found that campaign managers know very well who is running ads that benefit the candidates. They know when and they know where the ads are being run. And the lobbyists? A prominent lobbyist testified that lobby organizations use issue advocacy to influence members of Congress. Members ask corporations and unions to run issue ads on their behalf. A member of Congress may suggest that corporations or individuals make donations to interest groups, donations that will help the members campaign. After the election, these interest groups often seek credit for their support. Does any of this color public opinion? Yes. A large majority of Americans, 80%, think corporations and other organizations that electioneer for specific officials later get special consideration on official matters that affect the electioneers. In summarizing her findings, Judge Collar-Cotelli wrote, "The record powerfully demonstrates that electioneering communications paid for with the general treasury funds of labor unions and corporations endears those entities to elected officials in a way that could be perceived by the public as corrupting." This court's myopic focus on quid pro quo scenarios overlooks the deep historical roots of our nation's understanding of corruption. The framers were obsessed with the subject. During the Constitutional Convention, the threat of corruption came in for more discussion than the threat of factions, violence, or instability. When they created our Constitution, the framers had their sights set on corrosive threat to Republican self-government, of which this court seems blissfully unaware. That corporations differ from human beings should need no elaboration. Today's majority opinion ignores the difference. Unlike natural persons, corporations have limited liability for their owners and managers, perpetual life, separation of ownership and control, favorable treatment of assets, all of which enhances their power to use capital to maximize return on shareholders' investments. Unlike voters in United States elections, corporations may be under foreign control. Unlike other interest groups, business corporations have a delegated responsibility for society's economic welfare. They shape the life of every citizen. Yet the size of a business corporation's treasury is not a valid measure of popular support for its political ideas. It reflects instead the economic decisions of investors and customers. Yet a big treasury can magnify a corporation's political presence far beyond the power of its ideas. And what about the corporate coercion of shareholders' speech? When a corporation uses general treasury funds to praise or attack a particular candidate for office, who foots the bill? It is the shareholder who foots that bill as a residual claimant on corporate assets. As a result, shareholders who disagree with the corporation's political message may find their own investments at work against their own political convictions. So, contrary to the majority opinion, corporate electioneering is likely to impair compelling governmental interests. And, contrary to the majority opinion, government can restrict corporate electioneering without encroaching upon First Amendment freedoms. Corporations lack conscience, belief, feeling, thought, and desire. Oh, yes. They can shape the activities of human beings, to be sure. And their personhood often serves as useful legal fiction. They can sue, and they can be sued. But they are not themselves members of we the people, by whom and for whom our Constitution was established. In conclusion, in a democratic society, the long-standing consensus on the need to limit corporate campaign spending should outweigh the wooden application of judge-made rules. At bottom, this court's opinion rejects the common sense of the American people. Since the founding, Americans have recognized a need to prevent corporations from undermining self-government. Since Theodore Roosevelt, they have fought against corruption by corporate electioneering. It is 2010. It is a strange time to repudiate that common sense. American democracy is imperfect. But few outside the majority of this court would have thought its flaws included a dearth of corporate money in politics. The majority say, and so do I, that an ad for candidate Jane Doe must plainly say, "I am Jane Doe, and I approve of this message. This is a stand-by-your-ad disclosure requirement, pure and simple. The majority say, and so do I, that corporations and unions shall not contribute directly to candidates to avoid corruption, real or apparent, of the quid pro quo variety. But the majority also say that government has no compelling interest in keeping corporate money out of candidate elections. That I cannot say, and that is the fatal taint on this majority opinion. When the United States District Court upheld the Federal Election Commission, when it said the FEC had every right to apply its exclusionary rule to that anti-Hillary film, that United States District Court was correct. And the present majority is wrong. I would affirm the judgment of the United States Court for the District of Columbia. Yes. Yes, ma'am. Thank you. Thank you. Thank you. Author. Okay, you're hugging it. You're hugging a judge.
Thank you very much, Lois. Thank you very much for performing that for us. And I want to thank each and every one of you for coming this evening. I'm going to MC for a question and answer period.
Prudence, all the legal stuff. That's Stevens. That's all Stevens. None of that is mine. It's all Stevens. Yes?
Let me bring the mic back to you so everyone can hear you.
How is the donated money being used?
How is the donated money being used?
But what actions is the group taking to move to amend?
Yeah. So the money that we're asking donations for.
It's going to our organization to do things like print programs for you, things like that. Tommy?
Our next efforts are to go to study the state legislature, and because the state legislature is, they say, is more affected by this money than the federal government is. So that is very eye-opening. And so our efforts are going to be to try to take a resolution to the state legislature to ask the state to ask for a constitutional amendment, federal government.
David.
How many states are doing that?
We have a question in front first, and the question is, how many states are doing,
How, in terms of moving the country,
are making significant steps toward a resolution determined to revise the Constitution, amend the Constitution so as to declare that corporations do not have constitutional rights that are meant for persons, and money is not speech. Money, campaign money can be regulated. The count varies depending on who's doing the counting. The last figure I heard was 16 states have adopted resolutions of that sort, which they've sent in due course to the Congress, indicating this is what they want Congress to do. They want Congress to start the amendment process, which normally does start with a drafting of an amendment by Congress. After it is passed by Congress by a supermajority vote, at 2/3 each house, it then goes to the states for ratification. And as soon as 3/4 of those states have ratified it, it becomes part of the Constitution. 16 have done it so far, others are working on it.
Thank you very much for a compelling presentation. We are obviously in the midst of an enormous governmental crisis right now, brought on in large part by the Tea Party. And so my question focuses on a couple of elements of the funding of the Tea Party. Do we know who are the funders of the, it seems ironic since some of what they're doing, if they hold up raising the debt ceiling, might actually bring on a huge crisis of capitalism. But I do know I looked at the funding of Congressman Todd Young, and he has every corporation that you can imagine in your darkest dreams is part of Congressman Young's funding. But I wonder what we know more broadly about the funding of the right-wing extremists in Congress.
The question relates to the funding of the Tea Party and other such organizations. Where do they get their money? This is a matter of public record in many cases. You can go to the internet and find organizations that are tracking this, and you can get answers to the kind of questions you've had. Rather specifically, if you wish, it's there. But to focus in on our own region, one way of answering your question is to point out that at the beginning of the final election for Congress here, Yoder v. Young, Young started with $1.2 million in his coffers. Shelley Young started with a credit card. By the end of the race, he was up to $1.5 million, and she was up to about $300,000. That's what you're up against.
What happens to these dissenting opinions? Are they just filed in a law book? Is there any precedent that cases get overturned and dissenting opinions are brought back forward? Did the other justices get a copy of his dissenting opinion, and did they read it?
Oh, yeah.
Okay. All right, the question is, what happens to dissenting opinions? Sometimes, as he said, they enter the history books as magnificent statements about American constitutional interpretation. And often they turn out to be the correct interpretation in the sense that later on some court, some Congress had accepted it, adopted it. Look at how many times we've amended the Constitution to take care of erroneous majority opinions. Dred Scott was a majority opinion. Fugitive slave law. We had to have a civil war to take care of that, and it resulted in 3 constitutional amendments against slavery also. Constitutional amendments. Now, there were the dissenting opinions there, and eventually they were proved to be correct, by our lights at least. So sometimes that's what happens. Sometimes they become part of the majority philosophy, the majority political sentiment of the whole country. Sometimes that happens. I think the country is with Justice Stevens in his dissent. I really do.
Hold on, I got one back here. I'll come back to you.
So just as intellectual curiosity, in the majority, were there any that were teetering close to the opinion of Stevens? And what do you know about how those individuals might have been persuaded to go one way or the other?
The question relates to the exact sentiment among the members of the Supreme Court as they voted in this case. He's focusing on the 5 people who voted in the majority. Were some of those perhaps leaning in the other direction? You'll find if you read these opinions, and you can read them for the most part, things aren't so simple. Things aren't so simple. Sometimes a person will vote with a majority while having serious and really valid reservations about the way he's voting. I would take Justice Stevens himself as an example. In the Bellotti case he talks about. You wouldn't know it from his discussion of Bellotti, but he voted in the majority in Bellotti to keep corporate money, to let corporate money into a referendum election. He voted with the majority. But he does not, he says that specifically, I didn't vote with the majority to extend First Amendment protections to corporations there. That's not what I had in mind at all. What I just meant was that I don't think referendum elections are that important to the government, not nearly as important as candidate elections. So there's an example where he seems to be in the majority, and frankly, most constitutional scholars disagree with him. Most constitutional scholars see Bellotti as an important step toward First Amendment protections for corporations, unlike him.
Thank you. When this move to amend the Constitution does reach the state level in Indiana, can you anticipate what line of argument will come forth to oppose this move?
The question concerns the day when this resolution is presented to the Indiana legislature. What do I expect the arguments for and against to be? That depends on who's in the legislature at that time, doesn't it? And some legislators I know have high hopes about a change in the composition of our legislature by then.
Yeah.
So it's kind of hard to say. But if I were trying to formulate a defense for this, I would have them read Judge Stevens' dissent. That's the most powerful reason I can think of, most powerful argument I can think of for supporting such an amendment. The whole idea is to keep corruption out of our elections. And to do this, you have to put regulations in place. You have to start